All right. Good evening, everyone.
Good evening.
Good evening, everyone. Yes. I trust and believe we are all fine. As we are still waiting for our lecturer, that is Professor Dr. Charles, Professor Dr. Charles, will try to go through the court structure and the jurisdiction of the courts which we have here in Zambia, civil and criminal procedure. It's one of the very important topics in civil and criminal procedure, and being people who are going to do moot court, we at least need to have an idea of what our courts can do. We need to have an idea of the court's jurisdiction as well as which type of courts do we have here in Zambia? All right. So I know, according to our policy, we need to start asking questions when we are about to be done. Though with me, I like in most cases asking questions. Despite that, I'll follow the topics which we in short the policy. To start with, we need to ask ourselves, what does the word jurisdiction mean? All right. So the what has come, our lecturer has come. I think I'll end from there. Oh yeah, I think maybe.
Hello, nice greetings to all of you. Sorry for the late. Actually, there was some interruptions that made me to come late. So sorry for any inconvenience. Hello, can you hear me?
Yes,
Can
Professor
everyone hear me?
Charles. We
Yeah,
can
we
hear
can hear
you.
you.
Yeah, welcome to tonight's class. We shall discuss introduction to mooting.
Yes,
Yeah,
sir.
this is continuation of the previous class we had. So, as a matter of fact, I will still summarize the book once more. Then you can ask your question. Maybe if you might have finished reading the book, for people who are serious, you can still ask some question. But when you want to ask, you can just say, "I saw so place, so page." It can be specific in the place you saw, so I can be able to check what is written there to remind myself. I can be able to answer the question. So tonight, I want to say that Moot is decided not on the Moot is decided not on the merits of the law, but on the counsel's persuasiveness. Moot is how you, as in how you can be able to convince the courts. That is what matters. There's something I forgot. Thank God for today's class. Please, even in that mooting and the courts, English is very, very sine qua non. You must know how to write, read, and speak. Very, very important. Because some judges will use it to mess you up. There are some things you say in a record, they say, which school did you go to? You know, that kind of thing is very embarrassing. So you need to know how to speak. There's something you write, they will ask you, which school did you go to? So you must know how to write very well. It is very, very important. Your use of English and communication skills must be very, very important. It's even better for you not to learn how to speak oral English. Most important is for you to know how to use the use of concord and how to punctuate. Punctuation is one of the things that are very, very important because you may punctuate wrongly. Like for instance, now some people will see where what is it called? Column. Some people don't even know what is column. You tell somebody to write I've seen a lawyer, you tell a lawyer to write a column, he will write semicolon for you. You tell you to write semicolon, he will write a column for you. You know, all these things are very, very important. As anyone who cannot even write a book. They cannot even write very well. It is important. I've seen some writers self. If they want to write, for instance, expand something, the normal thing to use should be column. They will put dash. Dash is wrong. Dash, the aim of dash is for you to use to combine two things. That is what dash does in use of English and communication skills. So all these things is one of the things that we should be acquainted with, because without I've written over 125, to say 120 law textbook, about maybe 125 textbook generally. Okay, I want to say a brief history of how I started writing. When I finished my secondary school, I got admission as a law student. Then I wrote my first book. I took it to the professor. Then I'm saying this for you to learn, sir. So when I reached there, the professor rejected my book. He said I wrote where he complained, he laid complaint on two things in my book that I said I did a repetition problem and a punctuation problem. I was mad. When I heard this, so I was like, and to be sincere with you, the thing demoralized me. I didn't write again until my 400 level was, and that time I could able to put something down. So I had to put something down. I took it to another person again. Thank God the man did not complain about those, though he what he did was rephrase. He rephrased some of the things. After rephrasing those things, so what he did again was, that was my first write-up I published. My first write-up was published in my 400 level. So I wrote the second one. I think it should be second semester 400 level. I think the man corrected a few things. Then the third one, no correction again. That's how I know I was perfect. And during that time, I wrote to one international journal. My first publication outside the OSA journal. I was made editor of also I became editor of one journal. Is the one Indian name? That name of that one is International Law of Journal. International Law of Journal, Science and the Technology. I think now I should be an editor of about 5 law journals, 5 law different journals. 5 law different journals. So why am I saying this thing? That maybe you might have written, he didn't write well, or maybe might have gone to Mooting, he didn't do well. Don't be demoralized. Failure is part of the things. I think I've told you my own experience, how I failed in that in my own aspect of writing skills. So failure is part of life. But the most important thing is that once you fail, you should try to stand again. But what makes you a failure is once you fail, you refuse to stand out, you refuse to try again. That is what makes you a failure. So maybe you might have tried in defense or in mooting or trying to come out to defend. You didn't make it. Let it not make you to be demoralized totally to the extent that I cannot come back again. No, try again. But what matters is that you should look those areas that you are not performing well. Those areas you are not doing well. You should now be able to do what? Go and work on it. As I told you, during my own time, my own problem then, they say it was punctuation. So I had to go back. That's why I'm very perfect in punctuation. There's no punctuation you mention now. I will tell you the use of that punctuation. So I had to go back. Okay, today I'm a legal scholar. Today, like last year, my book won the best book in the whole world. The best e-law bankruptcy in the whole world. My book won it. See, okay, this is the person that rejected his book for some years ago. But today, his book won the best law bankruptcy e-book in the whole world among 34 law bankruptcy. Even some of my seniors' books were rated. It was rated by CNN, Inc., Amazon, Book Authority, CNN, Inc., Amazon, Book Authority, and there's another thing. There are 5 that rated those books. So my book became the first for 2022, became the second in the whole world. It was best book written on 2022 because I wrote it on 2022. It was the second to the best in the whole world. So what am I saying? I just use this experience to tell you that maybe you might have tried. I know that some people are here who might have tried, or some people may even tell you you not make it. Don't listen to someone. Nobody is God. You can make it. What matters is that any area that you are told that you are not performing well, go back and learn it well. You can do better than others. Yes, you can do better than others. So that is it. So what matters is that once you are corrected, please try to take the correction. Don't feel inferior. Don't feel that maybe you failed. No, no one is perfect. We are all learning. Are you getting? So you don't know. You don't need to feel somehow because they have said that you didn't do well or you're not performing well. That is life. Life is trial and error. We keep trying. We keep learning every day. So what matters in mooting is this I'm saying now. You need to learn use of English. I don't even want to say you need to learn English. The difference between English and the use of English. You know, in English, you may know English now. For instance, I will say, what is a noun? A noun is a normal person, animal, place, or thing. But use of English means that you know how to use it. You can be able to use those. You can be able to use English. That is why that's why I'm using. That's what I'm using use of English. So in mooting, you must be able to do what? Use your English very well, especially use of Concord. Then you should be able to know how to punctuate. Punctuation is very important. So depending on judges, some judges frown at it, or some but it is one of the places they will rate you. But the most important thing again, which is persuasiveness, advocacy. But why do I say use of English? Because the court will look at what you've written so far. So then we even ask which school did you go to? Some of them will not come. You just say okay. I know that what makes you a good lawyer is for you to be able to defend yourself, for you to be able to persuade the judge, for you to be able to be good in advocacy, for you to be able to use the English very well. Because once there is error, your opponent lawyer can use it against you. That is the reason why you should try to be good in all round. Try to be good in all round, so no one can use anything against you. Even if they have used anything, if you notice it, try to equip yourself that side. It is very important. Advocacy skills, very important. Your advocate should be an excellent advocate. You should be an excellent advocate skills. If possible, practice. You can bring mirror. Look at yourself, practice, or you can go to your friend's present. See what I'm doing. See how I'm doing it. Am I doing it well? Let him or her rate you. That's another way of doing it. It is very important. Before you going out there to disgrace yourself or doing something else, why I'm talking on this English language is that this is one of the places I didn't talk the other time. I didn't discuss, or we didn't discuss the last time. So I need to say that English is very important, because people will think that English is not important at all. And as I've said, there is no difference between this mooting and the court. The only difference is just that mooting is students' own, court is real life own. It's just like you mocking something, but that everything you see here, that's what you see there. If you're not doing well in mooting, you cannot do any magic in the real courts, please. No magic. Because as a matter of fact, those law students are the people who will still later become lawyers. Those judges are people who will still become judges. So is there any other magic? No. So they are the same people. So you need to learn it now. Not that, to be sincere, not that if you don't learn it now, you cannot learn it later. No. It is a wrong impression. If you don't learn it, you can still learn it later. You can even still learn it later and be better than people who learn it now. But most importantly, the earlier the better. Make the hair when the sun shines. So it is very good for you to learn it at the early stage, so that you will not even disgrace yourself at all. You can check the case of Davis versus Boone, 1936. You can check the case of what is it called? Nomina versus Horseboa, 1967. You can check the case of Glow versus Frederick Beck, 1968. I think these cases will help you see how advocates goes. I think I can get most of them online. You see how advocates. There's even the one Serena pasted I think she posted it on the WhatsApp. That one is very good. You can see the case of Holder versus Holder, 1968. The researching is one of the most important thing in writing, because as a matter of fact, all this thing we are saying, all this thing I've been saying from day one till now, if you are not able to research well, you cannot do well. It is when you might have researched well, you are now equipped, you can be able to do what? Do all those things I've said before. But in a situation whereby you didn't research well, you cannot do anything. You can't do any magic. Research is very important. There's part, as a matter of fact, even if, let me just assume that some of you are here, you're not interested maybe in advocacy, maybe in being a practicing lawyer. Even if you're going to any other place at all, rather it is related to law. Research is very important. So I can equally advise you to do a course with also in legal research. Also has a legal research, and the legal research is very rich, so you can still do it. So it is very good. It will teach you a lot of things in research. If you do it very well, as in do the class very well, you can be able to know difference between, because a research is a very deep course. As a matter of fact, let me educate you on this. There's no course you study in the university you will not do research. Like me, when I was doing law was my first course. So when I did law, I did the research. When I did my second course was peace and conflict resolution. I did it as yes. I did it as my second. Is another course I did on its own. I did research. When I did management again, I did entrepreneurial management. I did research too. So research is very important. Apart from law, there's no course you do in the university that you cannot do research. You must do research. So it should be very good in researching, and they should learn how to research. But it is very, very important. A good researcher is a scholar already. Yes, scholar. Once you can research very well, there's nothing you will not learn. Because in research, and the research differs. Let me tell you the truth. How to research articles is different. How to research in writing a textbook is related to how to research in article. It's somehow related to how to research in project or long essay or thesis. But it's somehow different from how to research mooting. Because the reason is that the steps to take in writing a textbook is different from steps to take in writing a legal article. It's even different from a step to take in writing a social science article or law textbook. You will see, though, there are some things you see me, there is what is called synonym. You see me some things that are related, but they have some more differences or divergences. So, but once you learn it, once you learn it, any other one you learn it, they are related. First, if you want to research for mooting, I'll say the first one you should do is general reading. After general reading, the second one you should do is more scholarly commentary on the area of the law that you're researching on. The other one is now relevant cases, the cases that are relevant to the subject matter or the case you are being treated on. So you should, because once you do anything that is not, once you research on any case that is not relevant, you're already failing. You definitely lose the case. So these are the steps. The other one is you to summarize. So all these things are very important for you to do well in mooting. I've discussed written submission, how to use to submit, how to write, which I discussed vehemently on use of English and communication skills. It is very, very important. It is very, very important. The other thing again is that mode of writing. How to draft appeal submission is not how to draft high court. there are some dichotomies, there are some differences on there. You need to be acquainted with it so that you can be able to do well, because your opponent will use it against you. You can still check the case of New South Wales versus Lepo 2003 in respect of the appeal. You see what happened there in scope of duty of care owed. You check the case of Commonwealth versus Introven 1982. You can see the case of Sheikh versus Australian Capital Territory Schools Authority 2000. You can still see the case of Devries versus Australian National Railways Commission. Force versus Passy 2003. All these cases will help you in mooting. Commonwealth versus Introven, I've said it before. All these cases will help you in mooting. Young versus Young Shall Council versus Shet 1980. Romeo versus Conservation Commission of Northern Territory 1998. Woods versus Multisports Limited 2002. You can see, okay, I think I've mentioned this one. Okay, Baker versus South Australian 1978. Gaya versus Downs 1977. But let me still repeat this thing again. Once you are doing any case, it's always very important for you to update yourself. Make sure you're getting most recent cases. Make sure you're getting most recent cases. You don't just get an outdated cases. For example, that's the reason why if you're a lawyer, okay, even if you want to, you can even be getting what is it called decided cases. In Nigeria, it is called Nigerian law reports. I think it should be called Zambian law reports. If you're in Zambia, it should be law report. I'm talking about law reports. Always get if you're getting law report, always get supreme, the most highest court in your country, the most highest court law report. It will supersede every record because of hierarchy of courts. Because if your opponent is quoting a decided case that is, let me just assume that your opponent is quoting a decided case of high court, and you're not quoting a decided case of Supreme Court, it will supersede it. You're winning. Do you get it? So all these things are secrets you should know about law. The other thing again, in law, we are equally using textbook. You can equally use this mooting textbook. Can equally use maybe any law textbook or law journal. Let me just say, like in also we have a law journal that's called African Law Journal. You can still contribute. We accept students' articles there. We will accept lawyers' articles, even professors' articles, depending the person that writes it. We accept all of them. So you should equally be quoting legal articles, write-ups, textbooks. But know that textbooks are persuasive. They are persuasive, obitadictum. They are persuasive. They're not something that's, but if you quote, like someone that quotes cases by once you quote a Supreme Court case, it is binding on that case, except there is what is called sifting in law. Sifting in law in person whereby maybe the case, there is a difference between that particular case you're quoting to the present one you are defending. But once they are the same thing, the judge has no option whether to do what? To oblige, to accept your decision, to accept your persuasiveness, to accept your submission. So that is it. But once you're posting like textbook, law journal, even any law textbook, you're just trying to persuade it is acceptable. Are you getting me? It is one of the ways to persuade the court. All of them are called authorities. Even acts, laws that are accepted. But what supersedes all of them is cases, Supreme decided cases, Supreme Court decided cases supersede all. That's the reason why I say research is very, it is during that research you need to research all these things and get your materials and get your authorities ready. Make sure your authorities is the highest one. Most important, the Supreme Court decided cases. You supersede all of them. Thank you for listening to this lecture. If you have any question, you can go on and ask. If you have any question, you can go on and ask. Hello, I'm listening. Okay, I think there's.
Sir, it appears there are no questions, so maybe we can end the meeting and people will ask in the group if they have questions. I don't know if there's anyone else with a question, maybe they can raise it right now, but it seems like there's no one.
Okay, no problem, no problem. Thank you.
It's not a question, but it's simply a request. Kindly asking if you may just send the cases that you were saying, because I missed a lot of them, and then you just send a list of those cases to the group.
Those lists of those cases I mentioned, all of them are in also Moot material. All of them are there.
All right, thank you.
You're welcome.